Good evening, members. Welcome you all for this very interesting and unique session on writ and other constitutional remedies for income tax matters. To handle this, we have a very senior member of our profession, turned advocate, senior counsel of Rajasthan High Court, and handles most of the cases in Supreme Court, is none other than our Sanjay sir. Welcome you, sir.
Thank you. Thank you so much.
We love to hear your speech. Members, it's a very interesting session because majority of the members we are in compliance only, not in litigation practice. As you all know, Constitution is the source of whole legal and administrative framework in India. All the pillars of legislative, administrative, and legal framework are based on this Constitution. There can be no laws in India which violates the fundamentals of Indian Constitution. It is a conceptual framework for the legal and administrative statute, and compared to any other countries, there are a lot of litigation. Number of litigation is very high, time consuming, as well as cost involved also. Many of us know what are the remedies available in Constitution, whatever the tax disputes are there. We have very limited knowledge on that. Generally, we will go for appeal, CAT appeals or tribunal. If it is a question of law, again we will go for High Court or Supreme Court. Beyond that, what are the constitutional remedies? What is the protection for taxpayers? Sanjay sir is going to explain. He is the best person to explain this on this topic. Once again, welcome you all for this program. I request Secretary Pramod to give a brief introduction of sir. Thank you.
Thank you, Chairman. I take a very proud privilege in introducing a chartered accountant turned lawyer, designated as senior advocate by High Court of Rajasthan. He has experience spanning 31 years in the field of commercial laws, including taxation, corporate laws, economic offences, FEMA, real estate, intellectual properties, etc. Founded Chiramrit Legal LLP. Prior to founding Chiramrit Legal LLP, he was a senior partner at Mrs. Kalani & Co., Jaipur, a leading chartered accountant firm in Rajasthan. Master of Laws from globally renowned Columbia University, New York, in global business laws. Top ranker in international commercial arbitration from ICADR, NALSAR, Hyderabad. Successfully litigated on domestic and international taxation, commercial laws, and transfer pricing before tax tribunals, high courts, and Supreme Court, and also has several landmark judgments to his credit. He advises corporates and family business. With this brief introduction, I welcome you, sir, and I would like to present to you to our members.
Thank you, Chairman and Secretary of Bangalore branch, and it's really my privilege to be with you this evening. And the topic which Bangalore branch has given to me is very, very interesting. Friends, I'll tell you that I practiced as a chartered accountant from 1991 till 2001. And from 2002, I started law practice, and it has been now 20 years in law practice after 11 years of CA practice. So what I feel during the entire span of my career, that while I was arguing the matters before the tribunal as a chartered accountant up to 2001, I considered Income Tax Act to be my Bible. And that is how, so whatever is mentioned in income tax law used to be a final word for me. And that's how I studied income tax law. That's how I preached income tax law. That's how I taught income tax law to the CA students. And that's how I practiced income tax law. But the moment I switched to legal practice and became member of the bar and started practicing at High Court, so I considered income tax law not to be the Bible, but Constitution of India to be the Gita. So that was the major change in my approach to income tax when I started the practice at High Court. So I'll give you a simple example. While before my practice as a lawyer, every answer I used to give to the client was based on the income tax law, that because it is mentioned in income tax law, therefore this opinion is correct or this view is correct or you have to do this. But thereafter, what I realized is even what is mentioned in income tax law could be incorrect on the parameters which are set in the Constitution. And therefore, I should not limit myself to the income tax law. Even the law could be wrong. And that is what, when you start the practice as a lawyer, comes to your mind. That you are not required to confine your answers from income tax law or any other law. You have to go beyond the law and go to the mother of all laws, and which is the Constitution of any country. And in our country, it is Constitution of India. So the moment I switched to that practice, I started feeling critical about the income tax law itself, thinking that why is this provision like this? Why this particular provision should not be challenged as an arbitrary provision or things like that. And just to recall before I take up the topic of the day, there was an explanation AA below section 80 HSC in income tax law, which provided an explanation as to what is counter sales and where the export benefit was prohibited by way of an amendment through insertion of the explanation. So while a chartered accountant, as a chartered accountant, one would think that it is a retrospective amendment and therefore it has to become applicable in all those years from which it has been made applicable, and therefore 80 HSC export deduction has to be disallowed. As a lawyer, I thought that no, how the legislature could bring a retrospective amendment like this? When I made the export, I was entitled to export exemptions, export deductions, and when I filed the return, if I am not entitled or at the time of assessment because of the retrospective amendment, this is something not expected of the lawmakers. This is what I should challenge. So that was the first matter with which I encountered, and I prepared a writ petition challenging that matter before the High Court, and we succeeded. Ultimately, the Supreme Court declared that it is a substantive amendment brought under the garb of explanation. Therefore, it would apply only prospectively and not retrospectively. And therefore, the counter sales for the period before that would be entitled to deduction. It is a different matter that even thereafter, in one of the matters, on the basis of the principles of constitutional interpretation, it was held that despite the explanation, the main section would govern the law, and therefore we have not to give that weightage to the explanation, and we have to read down the explanation in light of the main provision. So that is how my journey of a lawyer started when I shifted from chartered accountancy to law. And I found in last 20 years that I'm growing and still growing, and I'm learning many more things beyond income tax law, and that is helping me to understand the income tax law better. And friends, all of you know that what is happening to 148 and writ petitions in High Court about 148. It is becoming very, very interesting how Supreme Court has dealt with the Ashish Agrawal's judgment, and how Delhi High Court has recently dealt with some of the 2013 and 14 assessment year matters, and how Bombay High Court is dealing with these matters, and how what shape it would take in Supreme Court. But let us understand some basics, because we are understanding the constitutional provisions relating to income tax. And before I take up my slides, you must all know that apart from, as a chartered accountant, you are not required to go through the entire constitution. But you must know at least few provisions if you are tax practitioner. Like you must know Article 265. That's a must for you. So unless you know Article 265, I think your study of income tax or GST or any other tax is not complete. Because Article 265 says that no tax can be charged or recovered unless or without following a procedure prescribed by law. So now that means that if whether it is a recovery or it is charging of tax, if it is without following proper procedure as mentioned in law, then you can directly approach High Court or in Supreme Court in appropriate cases, saying that no, this is breach of Article 265. And therefore, it cannot be allowed, because Article 265 says that whether it is recovery of tax or it is levy of tax, they cannot be without authority of law. And in our case, they have just recovered, and the recovery provision does not entitle them to make recoveries like this. So we can directly attack such illegal actions by way of a writ remedy. Similarly, we must also know what is Article 141. All chartered accountants must know that. Article 141 says that if Supreme Court has ruled something, then that becomes the law of the land, law of entire country. And therefore, everyone, including the assessing officer or other authorities, have to follow that. They cannot breach the mandate laid down by Supreme Court. And Supreme Court is said not to propound the law, but to declare the law already in existence. That means that whatever Supreme Court says has to be considered to have been part of the main law itself, whether or not it is written in so many words. And therefore, we must all know that Article 141 for us is very, very important. And if something has happened in Supreme Court and they have given a verdict, it becomes a rule of law for everyone. It becomes a line as if it is a line of income tax law, and that has to be followed by everyone. So apart from these two basic articles, we must also know that there is an article called Article 14. And that is about, it is a very small article, but it's very important article. Equity or equality, equality before law or equity under law are the fundamental principles of Article 14. An arbitrary thing can be attacked under Article 14 to be non-equitable. So what is arbitrary? Suppose assessing officer takes an action which no prudent person would have taken. Suppose before recovery from a person who is a taxpayer, he approaches the recovery from a debtor. It's not permissible. So if that is being done, one can attack under Article 14. And how do you approach High Court or Supreme Court? We have to approach Supreme Court in Article 32, whereas we have to approach High Court in Article 226. That is the section where you will make and draft your petition, you will present your petition and you will seek the relief. But your grounds have to come either from Article 14 or from the chapter of fundamental rights, chapter 3, or 141 or 265. So that is how the things would go. And now I'll take my slides, friends, one by one. And Chairman sir and Secretary sir, kindly let me know if my slides are visible to. So coming to the first slide, why do we go to High Court at all? Why not all matters are resolved through normal channel of assessment? There are several reasons. And one of them is that sometimes in the normal channel, the time taken is very, very substantial. And you can't wait for a relief until that time. Suppose your house is put on auction by a tax recovery officer. If you think that you will challenge in the normal course of matters, your house would be owned by somebody else, and tomorrow a third party right would be created and you cannot get a relief. Or suppose there is a 148 matter where order would be passed, and then for going to appeal, you have to deposit some amount, and you don't have that amount because what they are adding, you are a person having income of 20 lakh, and what they are adding is 20 crore. So even if they ask to deposit you 10% or 15%, that's going to be beyond your deepest pocket. So what will you do? So therefore, you need certain remedies very, very quickly and fast. And therefore, you cannot perhaps depend upon the normal channel of income tax department or remedies provided under income tax law. And therefore, you need to approach the High Court directly. And for that reason, that is one of the reasons why people go to High Courts in writ jurisdiction. Because the remedy is quick, because the remedy is less costly. Of course, accept the lawyer's fees. You don't have the statutory charges, you don't have the time cost, you don't have the cost of depositing the money in advance. So those things are not there in High Court. So therefore, many persons approach the High Court straightway, even where some alternative remedy is available, but that is proved to be inefficacious or non-effective. Then people like to approach directly the High Court. And please mind, there are instances where you have both remedies. There is a remedy of appeal in income tax law, or there is a remedy of any other fight in income tax law, and there is a remedy to approach the High Court. But if you go in a statutory remedy, what will happen? Normally, after going there, High Court does not entertain your matter. However, vice versa is not true. So if you have a limitation and you have approached High Court and you have just taken a chance and you get some benefit in High Court, it's very good. If you don't get a benefit, your statutory remedy still remains intact and it is not barred. You can still avail it. Therefore, there are people who would like to approach and at least explore the constitutional remedy when there are few percent chances of getting a relief. And if you find that if you have to stop the wrong action at the threshold, you want that, they have information, and what they are trying to do, that information is right or wrong. They want to, income tax department wants to enter your house through that flimsy information. And after they enter the house, they have several other reasons to justify their action. So you want to stop their entry in your house. You want that they should not enter your house. So instead of getting the assessment completed and thereafter challenging it to the appeal, you want that the notice itself should be stopped, or a stay should be obtained at the notice itself. So then the only remedy which you have is the writ jurisdiction in High Court. It is of course an extraordinary remedy. It is of course a remedy which the High Court would like to see that you are not coming only by way of a routine, and you have to make out a case that my case is extraordinary. Partly it will be what is ordinary and what is extraordinary. Partly it will be governed by the judgments and philosophy, but partly it is how you make out your case. Sometimes the people, one person can make out one case to be extraordinary, and other person is not able to do that. So you have to make out your case in a proper manner so that it can appeal to the court that this is a matter which deserves the extraordinary relief at the threshold. And this person should not be relegated to the department for its normal remedies, and he should be allowed the entry into the High Court gates for giving the extraordinary relief. My second bullet point on this slide says that for the matters like challenging the constitutional validity of any statutory provision, section, rule, maybe notification, maybe circular, Now there you don't have two remedies. You can't challenge a circular, or you can't challenge a statutory provision or a provision or explanation or a rule before the income tax appellate authority or the ITA. You can't do that. So if you find that the law itself is wrong, or the rule itself is wrong, or the circular is crossing its boundaries, or notification is beyond its authority, the only place where you can go is the High Court or Supreme Court in appropriate cases directly under Article 32. So there, what you have to really do is that you have to attack the constitutional statutory provision on constitutional grounds like virus. That this statutory provision is ultra virus the Constitution, or it is arbitrary, or it is unreasonable, or it is void, or it has not been passed through proper process. So these are normally the ground on which you will challenge a legal or statutory provision on constitutional grounds. Now, many times you have a reason to approach High Court because you want to enforce some fundamental rights. There is some illegality in the income tax search, or maybe income tax survey, or maybe some other department's action. There is some high-handedness, and you want to safeguard the interest of protection or fundamental rights. Or suppose there is a hamper, there is some problem to carrying on of your business because of one of the department's action. Where do you go and challenge that? And the only place to challenge that is High Court. You all know that, let's say that a department has seized some LIC policies during search, or seized some of those documents which you need for some other purposes, maybe some property documents. Whereas the department cannot normally seize, should not normally seize, I must say, the property document in their original. Because what department is going to do through property document is they are going to assess whether the investment is disclosed or not. So that can be done even through photocopies also. So what purpose would be served by seizing the original? There is a seizure of assets and there is seizure of documents. When they are seizing the property documents, it is in fact the seizure of document. But what they are trying to do through seizing the original document is they are seizing an asset, or they are attaching an asset. That is not allowed. Then suppose they have done that. How do you get out of that? The only place where you can approach to get out of that is the High Court, that they should keep the photocopies and release the originals, because I have to keep them mortgage, or I have to take loan against property, or I need them for putting as collateral, or I want to just sell them because I want to pay my tax liability and they have the original, so I can't do it. So you can get those released either through ombudsman. Department has initiated very good thing. It has set up ombudsman. So either through ombudsman, it is very, if it is active now and in your area, and if it is not a relief which ombudsman gives, or ombudsman fails to give relief, or you are not willing to approach ombudsman because you know what ombudsman is going to do, so then in that case, you can directly approach High Court for such remedies for which there is no appellate or statutory remedy at all. With that, friends, let us come to the next slide, which talks about the constitutional provision which become relevant when you need to know something about this subject. I'm showing Article 32 just for the provision that sometimes we feel that when we approach Supreme Court, it is only a secondary remedy which we can approach only after going to High Court. High Court is primary and Supreme Court is secondary. Friends, it is not like that. It is secondary when we are going in SLP, special leave petition. But it can be primary under Article 32. You can first approach Supreme Court directly. Of course, Supreme Court deprecates normally these kind of practices where normally you should approach High Court, but sometimes it becomes necessary for you to approach Supreme Court directly, and therefore the law has an enabling provision under Article 32. Constitution has that if something comes where your liberty of any kind of liberty, freedom or any kind of liberty is being blocked by the income tax department or through an action of the income tax department, there is a way you can directly approach Supreme Court. And suppose you find that there is something like a previous judgment where Supreme Court has already declared the law and you should get benefit out of this, and the authorities are not giving benefit of that. I think in that case, if you directly approach Supreme Court, you will immediately get relief. So there are many cases like that. I'll not much discuss this because out of the constitutional remedy, this is relevant in 1% cases. In 99% cases, what is relevant is the remedy before High Court. So we'll devote more time on the remedies before High Court. And I'm skipping this slide for this purpose. So before High Court, the relevant article where you approach the High Court is Article 226. And in this 226, you have the High Court's power to issue writs. And what kind of writs High Courts can issue? Before that, what we must know is High Court can issue the writs for enforcement of any of the fundamental rights. Part 3 means fundamental rights. Part 3 of the Constitution is fundamental rights. We as citizens must know Part 3 as well as Part 3A. So, but here today, that's not the topic. So, we must know that Part 3 contains fundamental rights. And if we have to protect, if we feel that our fundamental rights have been breached or attacked, then we can approach High Court under Article 226. Other than that, Article 226 is so wide that it says that you can approach the High Court for enforcement of fundamental rights under Part 3 as well as for any other purpose. So that would mean, friends, that practically for every purpose, wherever you feel that there is a breach of constitutional provision, you can invoke Article 226. So be it a tax provision or any other provision. You find that there is somebody who is falling in the definition of a state or the government officer, if they are breaching their duty, or in some cases, if they are not performing their duty, both the cases, if what they are doing is against the law, or they are not doing what they should have done as per the law. In both the cases, you can approach High Court. Or they have started a process which is contrary to the law, and you want to get a stay and stop them at the place where they are. So you can get different kinds of writ issued against them. So Article 226 before High Court has much wider connotation, and therefore I mentioned that in 1% cases you could invoke Article 32 in tax matters, but in 99% of the tax matters where you feel that your it's a fit case for writs, the proper place would be High Court. And definitely you have to go by territorial jurisdiction. It's not that you can hunt the forums and you can approach any High Court. You have to approach the appropriate High Court only, the jurisdictional High Court only. And with that, friends, this any other purpose has been discussed in several judgments by several courts. And not only for enforcement of, in the previous side, what we saw, breach of fundamental rights. Where are fundamental rights mentioned? Part 3 of the Constitution. But there can be breach of legal rights also. Where are legal rights mentioned? Legal rights are mentioned in any of the law, not the constitution. Any law like Income Tax Act, like Companies Act, maybe like GST law. So they are called legal rights. Fundamental rights or constitutional rights are those which are mentioned in the constitution. Legal rights are those which are mentioned in any of the enactment below the constitution, like maybe enactment passed by parliament or by assembly. So suppose you are entitled to take photocopy of your seized papers or entitled to take the copy of the statements recorded under any circular or law or rule, then you can, and they are not giving it, you can approach any other purpose would cover it, and you can approach the court for getting it. And that is what is legal right and enforcement of legal right through court by approaching the High Court in Article 226. Similarly, friends, suppose the department or somebody in the department is not performing its legal duty. Your refund is not being given. Let's say, very simple example. You have been granted relief by appellate authority and department is not giving appeal effect, because appeal effect would result in a very good amount of refund to you, or they are not processing your return because it would result in a big refund. And you give them reminders. You approach them twice, thrice, but where do you go next? It is they are not performing legal duty. For performance of their legal duty, or in other words, for enforcement of your legal right, you can approach the High Court in this limb of the provision, any other purpose. It will definitely fall in this part of the constitutional provision mentioned or captured in under Article 226. Now, friends, legal duty, there are several other things. Suppose you have given a representation to the department, maybe to CBDT, to issue a clarification, because the provision is has some ambiguity and they are not issuing the clarification, and therefore the lower authorities or the assessing officer are adopting an interpretation which is absurd or which is in favor of the department and not a reasonable interpretation. At the same time, CBDT is not issuing the clarification. You can give CBDT reasonable time and then you can approach the High Court. High Court would mandate CBDT to issue the clarification within appropriate time. Friends, before I take up my next slide, you must also know that there is something called Article 227. You have Article 226, you have also Article 227. And what is Article 227? Very interesting. Every High Court has a power of superintendence over the judicial court or tribunals within its jurisdiction. That means suppose there is ITAT within your city or state, and that ITAT is not functioning properly, or ITAT has some other issue, or it is not following the rules of law or certain things very properly. It's not pronouncing the judgments in open court. It is not granting the hearing. It is not fixing up the matters. The system of acceptance of appeal is not correct. Opportunity of hearing is not proper. Whatever. So in all those cases, you can invoke Article 227 rather than Article 226, because their boss is High Court. Tribunal's boss for superintendence is High Court. So you will approach the High Court only for the limited purpose that you are the superintendent of this tribunal who are not functioning properly. Please direct them to function properly. I have seen the cases where tribunal sits only 3 days in a week because of some problems, and people have approached High Court to seek a direction to tribunal and the tribunal president and the government. that they should function properly. How do we get relief? Where do we go when we have to get a stay from ITAT? So these are the matters where you can approach the High Court in Article 227 and request them to exercise their power of superintendence over the judicial authorities within their domain and within that state. So I have used it a couple of times, and when the process of terminal was uh, grossly wrong, or not appropriate, or beyond the principles of natural justice, I have approached the High Court to seek directions to the tribunal that they should mend their ways. So, friends, that's another very, very important article. And in the matters where I have used, apart from 2 or 3 individual matters, I recollect that I have used in the matters relating to tax bars or tax associations. They can, because they are the real bodies who will approach the High Court against the improper or unjust or a different manner of functioning by the tribunal or lower authorities. Friends, under income tax, this slide on your screen shows the most popular writ petitions. I'm not saying these are the only sections where you can file the writ petitions, but these, but number-wise, they are most popular. And I like explain or mention everything. So 147, 148 is the section. You know that assessees are flooded with these notices. But at the same time, you must also know that all high courts are also flooded with writ petitions arising out of 147 and 148. Because this is the grossly abused section by Income Tax Department. And therefore, the assessees use this forum for getting direct relief from the court, and they challenge the notice at the threshold itself to the High Court. You all know that now there are new provisions. So at what stage should we challenge? Is it at the stage of inquiry? Or what stage? The cardinal principle, however, is that you have to at least meet the preliminary requirements of the notice. And then you can challenge. It's not that you should in every case straightway go on receiving a first notice under section 148 capital A small a. Many times you should, and most of the time I would say, and that's the practice which I follow, I would like to first make objections. And after making objection, in the meanwhile, what I would like to do is, I would first seek the information from them. If the information they have not provided completely, I'll first seek the complete information because that is the mandate of the law. Once, now reason to believe word is not there, all of you know. And therefore you will not ask for reason to believe. Law has changed and law has the word information. And the word information has been defined in the law. And they have captured that 2 things could be considered to be information. And you all know, therefore I'll not repeat that. It's captured in the law. Whether it is arising out of the risk management strategy of the department, some information props up on their, I should say, a software which through artificial intelligence raises red flags. And those red flags are considered to be defined under the income tax law to be the information. So that is the first thing. So, and that is the main thing. So after the information you receive, then what is required normally is that you should challenge it. If you feel that the information is not correct, or you feel that the information is partly correct, or you feel that information though correct, but is not being interpreted properly, or you feel that this is already disclosed, these may be the primary grounds of objection. that though the information is correct, but the transaction finds a place in your return. So where is the need of 148? So in those cases, in all those cases, you would like to challenge it. I think what I would like to do, Chairman, is that I would pause for some question answer, because it should not become very, very boring and a monologue. There should be a dialogue, because 147 is a most talked about section these days amongst chartered accountants, and they are struggling with their clients and handling these 147, 148 notices, how to deal with them, in which cases to approach High Court, which not. So at this stage, chairman or secretary, whosoever wants to intervene, I would like to seek indulgence of some of the members from audience. If they have any issue on 147 or 148, because this is a burning topic. Today itself, I was appearing in Rajasthan High Court in a very, very sensitive matter, and I got stay in about 7 or 8 cases from the High Court on 147 notices. The matters were interesting. Court heard me at length for about 45 minutes and then granted the stay. So every day I encountered several interesting issues in 147, 148. Today also I argued 3 different legal matters. In the 8 matters which I argued, there were 3 different legal issues. And therefore, what I feel is the audience should indulge in a discussion at this stage. If they have any issue or they want to discuss anything about 147, 148, in which cases should we go in writ, in which cases we should handle it with the department. There is a different approach to deal with the assessment years 2013, 2014, and 2014-15. There is a different approach where more than 3 years have elapsed, and there is altogether different approach where the notice is within 3 years of reopening under the new provisions. So most of you understand the distinction and also understand the various deficiencies in their process or notices or information, or one of the most common issue which arise out of the information portal of the department, because most of the reopening are in respect of shell companies which their software indicates, or which are listed as shell companies before SEBI, or maybe the high value transactions which are highlighted because they are being picked up by the artificial intelligence software of the department, and that software has raised a red flag because the transaction is not matching with the profile of the person. So these are the primary reasons. But if you guys have any issue or question regarding 147, 148, how to handle them, which matters should we go in that petition, kindly don't hesitate to ask at this stage. So meanwhile, I'll have the opportunity of having a sip of water, and you may ask your questions. If the chairman or secretary are hearing me, kindly motivate the audience to ask some questions on this. Can I have the anyone out of chairman and secretary, if you are there? Well, let me first take up the subsequent points, and perhaps then the audience would be able to ask the questions. This article, section 2206. Yes, sir, Chairman, sir.
Sir. There are
Anyone?
3 questions, sir.
Yeah. How can I have the questions? How do I read the questions?
I think 3 questions. One is in another one question in chat.
In the chat. So can you
Sir.
read the question for me? Because
Yes, sir.
I cannot see the chat on my
I'll
screen.
read out,
I
sir.
have the presentation.
Yeah, question 1 from Gella Praveen Kumar.
Yes,
Can the
sir.
judgment of High Court of a particular state be binding in another state till the same is not challenged? That's what is question, sir.
Yeah. So I'll explain this. Very good question. I must first compliment that. It's a wonderful question which is coming here these days. So firstly, a judgment of one high court has a persuasive value before other high court. It is not a precedent, binding precedent, but it has a persuasive value. But when the judgment of the high court, if it is not challenged before Supreme Court, you can take the benefit of one of the judgments of Supreme Court. I'll Blue Moon or something. I'll tell you the name of the judgment, which says that if the department has accepted one judgment in one particular matter in case of one assessee, it cannot take different stand because the high court is different, or because the state is different, or city is different, or assessee is different. Therefore, having accepted a proposition of law, a department cannot deal two assessees differently. So that's a wonderful judgment of Supreme Court, which says that in such cases, although it is having only a persuasive effect, but because of department's conduct, it becomes binding. Because department cannot do a challenge in one assessee's case and drop the matter in other assessee's case when the facts are similar. So indirectly, you can say that it becomes binding if it remains unchallenged by the department in Supreme Court. Now, I'll further suggest that suppose the department challenges in Supreme Court, and in Supreme Court, the SLP is dismissed. Again, technically, it is not binding, but again, normally the High Court feels that it is binding. So when it becomes binding principle as per law is when in Supreme Court, the matter is entertained and then dismissed on merits. If it is dismissed without admitting, it doesn't become law pronounced by Supreme Court. It remains law pronounced by High Court, not entertained by Supreme Court. But once they entertain, grant the leave, if they pass the judgment, it becomes judgment of the Supreme Court, and High Court's judgment gets merged into that and becomes rule of law of Supreme Court. Maybe Supreme Court passes only one line judgment after granting the leave of or admitting that, we are in full view, we are in view that the High Court's judgment is correct, or we are not inclined to interfere. In these cases, it becomes judgment of the Supreme Court. So I think I have clarified the doubt raised so far as the first question is concerned.
The second question from Soumya, whether writ and SLP are one and the same.
No, not Soumya. They are not same. SLP is when you have High Court's order, whether in appeal or in writ, any order or any other judicial authority's order. Why only High Court? Any other judicial authority's order. And there is no statutory appeal after that. If there is a High Court order and there is no statutory appeal after that, law does not provide an appeal, then Constitution has a special provision that you can approach the Supreme Court seeking leave to file appeal. Appeal is not right because it is not provided in the statute. If it is in a statute, it becomes a statutory appeal. If it is not in the statute, you cannot file appeal. You have to first take leave of the Supreme Court to file the appeal, and that leave is called SLP, special leave to appeal or special leave petition. Whereas writ petition, on the other hand, SLP is filed only before Supreme Court. Writ petition is filed either before High Court or before Supreme Court. And as I mentioned, only 1% go directly to Supreme Court and 99% go first to High Court. So now, from this, what you understand is, writ, in High Court, SLPs does not go, only writ petitions go or appeals go. In Supreme Court, even writs go directly and SLPs also go after the High Court's order. So for SLPs, there is a different article. For writs, I have already dealt with Article 32. So there is a SLP has to arise out of High Court order, whereas writ is original jurisdiction of Supreme Court. So these two are very different things. So Soumya, I hope I am clear.
Thank you, sir. Another question from Vinay Sanji. During the processing of ITRs, department is not giving relief of foreign tax credit and is raising huge tax demands. Can it be a route to direct them to give credit of foreign tax credits, as despite making request for rectification, the department is not responding positively?
See, I would say that in appropriate cases, you must approach High Court in these matters, because their department is breaching the mandate of income tax law itself. Section 90 and 91 mandates them to grant such relief. And in Section 143, while processing itself, they should grant that relief. But if they are not doing that, you are approaching in 154. 154 is being rejected without hearing you. It becomes a very, very solid case. However, suppose in 154, they give you opportunity, and after that, they deal with the matter, and then they reject it. So in that case, it becomes a matter of appeal and not repetition. Whereas if they summarily reject it, don't hear you, or they don't do their statutory or legal duty, as I mentioned in the previous slide, they don't grant relief despite mentioning in the statute and the treaty and Section 90, 91 specifically. So you can directly approach High Court.
Thank you, sir. Another question from Mahesh Kumar.
Yes, sir.
Whether
Yes,
writ is maintainable in the course of summons or witness? Whether writ is maintainable in the course of summons or witness?
No, writ is maintainable at any stage when legal rights are breached. So you have to prove on the basis of documents that at that stage, what is your legal right and how it is breached. So in one of the matters, I would tell you that during the course of search itself, there was a search at a lawyer's place in Delhi. It's, I think, 20 years old judgment. And that lawyer was having some matters in court on the next day. But they were not allowing, income tax department were not allowing him to go to High Court to argue the matters. And they stopped him that you first get the search completed. So in that matter itself, he filed a writ. And the High Court was kind enough to issue strictures on the income tax department that you cannot stop. So even during search, you could approach in a writ petition. So during summons or witness also you could do that.
Thank you, sir. Question from Mahesh. One more. There is, okay.
Yes, sir.
Danesh Bapna. Sir, how do we deal with the recent Supreme Court decision in the case of
Ashish Agrawal?
No, Great Ship India Limited in the context of sales tax law, where Supreme Court has held that writ petition is not maintainable, where order passed is barred by limitation and relegated to assessee back to statutory remedy?
See, what happens is when the assessment orders are passed, Normally, high courts are slow in granting relief because they say now you have appellate remedies. Before orders are passed, if you approach the high court, they give relief if legal rights is breached. Once the order is passed, they say that now order is passed and you have a statutory remedy. Of course, Calcutta Discount Company Supreme Court judgment says that alternative remedy is no absolute bar. But normally, high courts are slow in giving relief once the final assessment orders are passed, even if they are barred by limitation. But on the contrary, I will tell you, in 148 matters, wherever they are barred by limitation, High Court is giving relief even if the assessment order is being passed. So don't get influenced by one judgment, and the law is such that if you can make out a distinction with the previously passed order, and you can make out such a case that I have the extraordinary circumstance, you will still get a relief, and you must try if your stakes are huge.
I think all questions are over, sir. Thank you, sir.
Thank you. So let me go further. There are matters where there is stay of demand application by the assessee and the stay is not granted by the assessing officer. Normally, you all know the circular of the department that if you deposit 10% or
Can I interrupt you, sir?
Yeah.
One more question is there.
All right, please ask.
When order is passed by the appellate authority,
Yes.
whether writ can be filed when tribunal is the next remedy.
That is a very difficult stage to find it, because you have a perfect appellate remedy. But suppose you feel that the appellate authority has breached your fundamental rights or has passed the order without granting opportunity of hearing, or has not admitted additional evidence, or has done enhancement of income. Now, these are the cases where I have noticed that during the course of my practice, only in these cases we have approached to the High Court against the first appellate order. Otherwise, in all general cases, this is not the proper stage when you should approach the High Court. You should normally approach the tribunal only.
Thank you, sir.
Yeah.
All questions are done, sir.
Yeah. So coming back to the next point, stay of demand. Now, all of you know that CBDT circular says that you deposit how much? 20% of the amount demanded and 80% is stayed. But the same circular also says that if in any case, the case is very, very appropriate for granting full stay of demand, then the department should grant full stay of demand. So suppose you, according to you, it is a matter of full stay of demand, but department is not granting that. So in such a situation, you can approach the High Court against the rejection of your stay application, or against the order where they grant only 80% stay against payment of 20%. You are seeking more than that. So you can approach the High Court that I am following the exception because my case is covered by Supreme Court or jurisdictional High Court or my own previous cases where I should have been granted the stay. So in these cases, the High Courts are granting stays. And I've seen your High Court and also Bombay High Court and also Gujarat, also Delhi and Rajasthan, MP. These are very, very proactive in granting stays in these kind of cases where prima facie the case is bad, case of the department is bad, but still they are demanding 20% of the demand. So there are various judgments of these several high courts granting stay. Now the next limb where ITAT orders is mentioned, section 254. All of you know that in 254, many a times you may read one of my judgments. Apex Metcam is a published judgment. So what had happened in that case, that ITAT passed an order granting relief to the assessee. And thereafter, ITAT passed an MA order withdrawing its order granting relief. So we challenged that MA order of the ITAT, that how can they change entire complexion of the case through an MA order by withdrawing the entire relief given in the main 254(1) order. We were successful in the High Court, and that's a reported judgment where I appeared long back, I think before 10 years. Like that, if you find that in the ITAT, whatever preliminary order is passed, suppose you raise a legal ground before ITAT as an additional question or additional ground, or you file an application for admitting additional evidences, and the ITAT's order is against you, still the final order is pending. If final order is passed, then you have to go in appeal before High Court in section 260 capital A. But before final order is passed, suppose there is a some kind of issue in the process or illegality in the interim order granted by ITAT. In that case, against such order, you can approach the High Court even before passing the final order. In search and seizure cases, the last limb in that slide, there are many instances, including illegal searches, illegal recoveries, illegal seizures, not giving the copy of statements, not making proper inventories, seizing the wrong documents, making the search at a wrong place, and in extraordinary cases, carrying out the search without proper reason to believe. So the searches have been challenged time and again in all courts, and in almost 30% of such cases, I've seen that the reliefs are granted by courts. In other matters, the ratio is higher. But to declare the searches illegal, there the high courts are a little slow. But even there, I've seen that in 30% of the cases, people are able to convince the High Court that the search action itself was bad, and therefore that should be quashed. In one of these celebrity judgments, because the search was bad, the consequential orders were also declared to be bad, including the assessment orders. So a person challenged the assessment order and the search together before the High Court and found illegality in the search itself. So based on that, even the assessment order was questioned. But that was an extraordinary case, I know. Normally, in search action, there is some illegality you find, arbitrariness you find, some unjust action on the part of department which you discover. One should definitely approach the High Court. Coming on the next slide. In 147, I've almost dealt with these issues that when normally petitions are admitted by High Court in cases of 147, 148. These are four major grounds. Limitation, time barred, or without jurisdiction, or non-existent information or reasons, or objections not dealt with properly, or procedure not followed. This is what I've already mentioned, change of opinion, CVP circular not followed. Now, 2206, as we seen in the previous slide, on what grounds it is challenged normally? Recovery without disposing of stay application. You have filed stay application. Department is still not disposed of that. And before that, they have done attachment of your bank account. It's a fit case to approach the High Court that they have not judiciously exercised their power under section 2206. So then stay application is decided, but without hearing you. That's another important situation when writ petition can be filed before High Court. You have civility circulars for granting stay, but the department wants 50% because their budget, revenue collection budget is there. You can actually approach the High Court that they are disobeying their own circulars. Now, where the discretion to grant stay is there, still they are not granting complete stay. So that is again one of the reasons for seeking indulgence of the High Court. Or they have disposed of your stay application, but it has been disposed of in just one line without dealing with your lengthy 7-page application, without dealing with the grounds and the hardships caused to you. So how to make a stay application is an art of chartered accountants. So they have to make it very beautifully, laying down all grounds why this is a very, very deserving case of granting stay. And I would suggest that you should file the stay application not in a cut and paste format of 1 page, but in 5-7 pages at least, describing how the additions are not good and not going to stay, describing the financial condition, describing the past history or similar cases, and the judgments by which the legal issues and factual issues are covered. Once you file such comprehensive and detailed application, and they dispose of through a 2-line or 5-line or half-page order, you can attack that in the High Court saying that they have passed a non-speaking order on your stay application without application of time, and therefore indulgence of the High Court is required. So, as I mentioned already about 254, how ITAT's order, in which situation ITAT's order can be attacked in High Court. I've already dealt with this part. If your rectification application is not being entertained, that is also one of the grounds of seeking indulgence of the High Court. Now, search and seizure. This is first one I've already dealt with. Second one, for release of assets. After search, what they should do of the assets is a subject matter of section 132 capital B. But suppose they violate that, they don't release the assets, or even before completion of your orders, you have some original documents, as I mentioned in the beginning, which have been seized as documents and not as valuables, because valuables can be attached, or valuables which are tangible and discovered and such can be seized. So it is breach of that. You can file a petition. In 201, recently I obtained a stay when it was a matter of reduction of tax from payment to non-resident. I don't know how many of you are aware that for raising a demand in 201, there is a limitation of 4 years when the deduction is required to be made from payments to resident. But there is no time limit in section 201 for passing an order where the allegation is non-deduction of tax from a payment to non-resident. So department in that case, says that no time limit. So we can pass 201 order even after 5 years, 7 years, 10 years. Because this 4-year time limit is applicable only for residents. We argued before court on the basis of 2 Delhi High Court judgments that in such cases, when there is no time limit mentioned in the law, then one has to go by reasonable time limit. And what is reasonable is indicated by law itself. Normally 148 now says 3 years is reasonable, but 201 itself says 4 years is reasonable for resident. So in that case, it was held that though there is no time limit in income tax law, but 4 years is considered to be reasonable time limit for passing 201 orders, even when the case pertains to non-deduction of tax from the payments made to non-residents. So they have granted stay. Of course, the department said that the purpose why legislature in its own wisdom has not mentioned any time limit is that it takes time to gather the information in respect of the non-resident. So it is intentionally they have left it open. But the courts and particularly Delhi High Court has taken a very, very strong and stern view against the department, saying that you have to let the assessee sleep in peace at least some day. You cannot keep the time limit open for his life. Assessee would like to sleep after at least some years. So if you have not mentioned any time limit, we'll presume 4 years to be the time limit. And very interesting judgments those are. Uh, uh, there are the case laws which are there in the slide, and I'll be happy to circulate these case laws. My colleague Rajat Sharma is sitting right beside me, and he'll be pleased to share all these judgments on my today's presentation with all of you through the branch on all these points which I'm making. Now, I will not deal with in detail what are the points on which writs can be filed in GST. There are many things which you can go through in my presentation. Primarily, you know that GST tribunal has not been constituted. So in most of the matters where the matter has to go to the tribunal, in fact, people are approaching directly High Court and writ petition, that we have a statutory appeal, but the appellate forum itself is not constituted. So where do we go? Where do we file appeal? Therefore, instead of filing appeal, we are coming to you in writ petition. So there are people who have to seek some stay. They are approaching it. The other people are not approaching, because all of you know there is a circular in GST. It says that this time limit for which the GST tribunal is not constituted, that would be excluded for counting the time limit for filing the appeal. So it's your choice. If you feel aggrieved for other reason, or you feel a cascading effect of one order in GST on the other proceedings, you should definitely go in there. Otherwise, you can wait if it is not affecting your demand or it is not affecting your refund. It may have, you have accumulation of GST credit. It is not affecting you right now. And you believe that GST tribunal will be constituted within a year. So in that case, you can go slow. But otherwise, if it is resulting in demand, stay is important for you, or you want to stop the cascading effect. In all those cases, even in GST matters, you should approach a writ petition. Friends, I'm happy to share that I was privileged to file the first writ petition in the country relating to GST and obtain a stay order from High Court of Rajasthan, which later became the foundation of grant of stay order by at least 7 high courts in the country. And that was when there were technical glitches in the software of the department, and because of which people could not file their options in time. And then because of that, they lost the opportunity because deadline was crossed. So in those cases, the High Court granted the indulgence by extending the time limit to approach in composition cases, and later that judgment was followed in many. And then the same thing for transition provision, there were many writ petitions in High Court so far as GST is concerned, that they did not get the transition credit because of certain faults in the system or by the department, or delays on account of certain other reasons. So in one of my matters where delay was on account of a bona fide mistake of a CA, where CA believed that this was filed, but in fact this was not uploaded in the system. So on the basis of some screenshots and on the basis of affidavit of CAs, we approached the High Court and we were successful in getting it. So there are many sub matters in GST, and it's a new law. So it has many matters right now. All of you know some of these matters. So I am available for Q&A on GST related matters. I'll be just running through the slides so far as the GST matters are concerned. So this is the first one, and you all know that section 109 of CGST and the state GST Act was challenged, and that became a subject matter of challenge for many assessees. And I am mentioned here the reported judgment also. And see here, apart from this, in CS, the other judgments which are there is Madras, or there are some other high courts who have also passed the order in 109. You may later go through the slide. And just before close, because the name writ itself is new to chartered accountants, so I must mention how many types of writs are there and what is the meaning of that writ. Now, writ is a kind of order or direction of the court. Issuance of writ means issuance of a rule of law or issuance of a mandate to an authority. So High Court's power of issuance of writ or Supreme Court's power of issuance of writ means their power to mandate or command their authority through a direction or a rule of law. So that is writ. So how many types of writs are there? There are essentially and ordinarily 5 types of writ, which are mentioned in these 2 slides. And habeas corpus is a writ, which means corpus normally means the body of a person, right? So habeas corpus is not that corpus which you have in trust or the capital fund. Here the corpus means the body of a person. So where any person is missing, or it is in the illegal custody of someone, and you want that person to be produced in court so that he can be released from court, or you can take with you, so then you file the writ of habeas corpus, and court issues the writ of habeas corpus and asks the state or the police department to produce the corpus before the court, corpus with the person concerned, and then this corpus can be released from the court at the instruction of the court on the basis of the decision of the court, which depends upon the arguments of the parties, of course. The writ of mandamus, on the other hand, is a writ where initially, if you remember, I mentioned that if the department is doing something wrong, they can be stopped by the High Court from doing wrong. But if the department is not doing what they should have done, then the High Court can issue the writ of mandamus, mandating or commanding or directing the government or the department or any government department to do what they are directing. So for seeking directions to a government authority, you can approach the High Court seeking mandamus, writ of mandamus. Then you have the writ of prohibition. Now, normally, writ of prohibition is issued by High Court to the judicial or quasi-judicial authorities wherever the proceedings have started, but they have not completed. And you want them to stop where they are. So you want to seek a status quo instead. At the same time, you want to put an embargo on the department or other departmental authorities or the government to proceed further in the matter because their action is illegal, unconstitutional, or ultra vires. So then you seek the writ of prohibition. Now you have writ of certiorari. Now this writ is being issued when the department or the government authority is passing an order or has passed the order without authority or beyond its jurisdiction or in contravention of any law or rule or principles of natural justice. Then you are seeking the quashing of the order. So quashing of or prohibiting the department from furthering the process is writ of prohibition. But quashing of the order is writ of certiorari. So sometimes you have to ask for both process and order. So it can be a combined writ. So normally when a lawyer would draft, he would draft that and seek from the High Court in the prayer part of the petition that please issue writ of prohibition, certiorari, or any other appropriate writ which is relevant in the circumstances. So it's like that. So quo warranto is a writ when you are seeking from the High Court to call any person to show to the court under which authority he holds the office and to oust him if he is holding the office without jurisdiction. So if you feel that somebody is illegally exercising the jurisdiction, he should not have. He is not the authority concerned. So you can ask the High Court that please ask him his authority. You cannot ask the authority because you are not police or you are not High Court or you do not have the constitutional power to do that. But High Court can ask that Mr. So and so, who are you? Tell me how you are doing this. What is your authority? So when you want to ask the authority to a person, please approach the High Court and High Court will be pleased to issue this kind of writ. And who can file it? Person aggrieved, of course. Yes. 148 notices, you can file it. You are the person concerned. Now, other than person concerned, if you feel that I am not the person aggrieved, but ultimately I'll be affected if this action is finalized by the authority concerned, and my rights would be affected adversely, then even a stranger can file a writ petition. And what I have mentioned, professionals or habitual litigants for cheap popularity or ulterior motives, they file a petition. But petitions are also in the nature of PIL. So public interest writ petitions can also be filed, which are the exceptions of this last one. And here the exceptions are mentioned. So if you feel this is a subject matter which is common and which is applicable to entire public and where private interest is not affected, it is a public interest which is affected, therefore writ should be filed, then it will be a public interest writ petition. Every High Court has different set of rules for PIL and different set of norms for admitting PIL and different set of process for admitting PIL. Like the Andhra Pradesh High Court, the Chief Justice has recently formed a committee that if you file PIL for 7 days, it will not be listed in court, it will be scrutinized by internal administrative committee, whether it is a fit matter which should be entertained by High Court or not. Once that is being done, then only it will be admitted by High Court. However, there are many other High Courts which are very, very liberal in PIL. And Supreme Court is the most liberal place for PILs. But the PIL has to be of national interest to prove that you are a genuine person, not the front of a private interest person, but a genuine person concerned with public interest. Then the Supreme Court or High Courts are pleased to entertain PILs. And against whom it can be issued, a small thing. Uh, uh, State is the word which is defined in Article 12. Government authority, central government, state government, or judicial or legislature, or local authorities, or any departments of central or state government, or any divisions thereof, departments like Income Tax Department. Against all of them, the writ petitions can be filed. Against a private body, it cannot be filed. These are the tests where a body is considered to be government, or the state where writ can be filed. Not relevant for you in tax matters, but relevant for you in other matters. Suppose you are seeking a claim against Hindustan Petroleum or Indian Oil. They are public corporations. But then whether they are monopolistic, whether they will be falling in state or not, that's a test which they have to satisfy. You have to satisfy before you want them to be respondents in a writ. This is what I would not like to deal with in this elementary session on writ petitions, because this should be done in some other session, maybe a subsequent session where the things can be discussed more minutely, because these are really relevant for lawyers and not for chartered accountants. And thank you very much. I think it was a session where I would have more enjoyed if I was physically present in Bangalore to meet you face to face, to see you face to face. But I think as a beginning, it is good that I had the opportunity to share my views on this topic, which is becoming very, very important. And I'll advise all those who want to find a different career and want to explore a different career, and who think that for them compliance practice is not appropriate, or at least one person in their office should advance his career in on legal side, I would strongly recommend chartered accountants to explore this side of the practice. It's not only very, very rewarding, it is good for your personal growth, because if you can represent your client up to a particular level, why not up to the highest level available in the country? And that is what was my thought when I surrendered my certificate of practice before 20 years and started the law practice. And today, with my experience, I can say that a chartered accountant turned lawyer is best fitted for tax, corporate law, and all matters where figures and balance sheet and commercial prudence is required. Because you are the blend of chartered accountancy, like very, very rigorous commercial course. You understand the numbers, you understand commercial wisdom, you understand the rationale behind a transaction. And if you start understanding law along with that, and then you become the spokesperson for a client before the High Court, I think that you can beat many lawyers, because lawyers would have the edge over you only for some years because their face is familiar with the code. But as the time passes, court would know that you can explain the substance of the matter better because you know the commercial things better. So I think that it's a good area for practice for chartered accountants, and the brighter ones must definitely explore the practice in High Court or Supreme Court on the basis of their legal acumen and on the basis of their commercial wisdom. And those who feel that they are arguing before tribunal and they are very logical in their argument and they are good in interpretation, they should definitely go. They should definitely try their hands because they have to step just one ladder more, and that's High Court. So with that, I once again thank the chairman, and if there are questions, I'll be happy to answer all of them. Thank you.
Yes, three more questions are there, sir. Question from Madhukar Hegde. What remedy is available for the order passed without considering the adjournment requests by National Assessment Unit?
I'm fighting similar matter in Jaipur and also in Delhi, and this is most peculiar. Fortunately, we have very good Chief Justice who has very bad experience of Income Tax Department. So if you have a judge who has very poor or bad experience of Income Tax Department, will definitely get a relief because they know that although this scheme is launched with all good intentions, and the scheme is very good, but the people have not been properly trained, and the technology has yet not been settled, and the portal is still not working that efficiently. I have a matter where I filed a reply, not adjournment, and it is not visible to them, and therefore they have passed ex parte order. So I'm saying to High Court, what is this nonsense? They are not understanding their own portal and the software. So I got the relief in that matter. So in these matters, if it is passed without providing opportunity, because you all know that in the faceless scheme, it is mandatory to provide proper opportunity. And if you seek hearing, it is mandatory for them to grant hearing. So if that's not there, you should approach High Court.
Thank you, sir. Another question from Praveen Kumar Gella. Section 83 gives authority for provisional attachment under GST law. Can this section be challenged for shutdowns where various instances due to non-filing of returns, bank account is being attached on a regular basis?
No. See, so for his first part of your question is concerned, Section 83, a provisional attachment, I don't think you will have a good case if you challenge that. Because this provision is settled in many other laws, and therefore provisional attachment, declaring that section itself bad will be a very hard or tough case for you. But your second part, there I find that you have a stronger case, that if there are attachments or recoveries or something like that, without following the due process of law or arbitrarily or in an unreasonable manner, that you have a case. So second part, I'll support you. First part, I suggest that it's a bad case for you.
Thank you, sir. All the questions are done. Thank you for an excellent session, sir. It has benefited our members richly. Really, I'm grateful to you, even in your busy schedule. You are attending this conference and guiding or addressing our members. I thank on behalf of Bangalore branch of ICA for your for sharing your knowledge, time and efforts. I thank on behalf of Bangalore branch of ICA. I also thank all the participants, those who actively participated till the end of this program. Thank you all. Thank you, Sanjay sir. I request our secretary to give a propose a vote of thanks, formal vote of thanks.
Thank you, Chairman. Thank you, Chairman. Firstly, I would like to thank Sanjay Jhanwar sir for making it convenient to attend today's session and giving his priceless experience. Thank you, sir. And of course, definitely for whom we have conducted this session is basically our members. Thank you for coming out in large numbers and registering for today's event. Thank you for making it a grand success. We look forward for you to interact in various other programs. And we would like to have an announcement by the chairman on the upcoming program.
Members, we have an upcoming program on the reconciliation of GSTR 9 and 9C on 12th and 23, and program on internal audit. And we are planning to have a program on for members on yoga classes. We want to have a conduct virtual yoga classes for our member from 1st of December. I request members, because see, we have to upkeep our health, mental and physical health. This is the best way to reach out our members. We thought of having this yoga classes from 1st December. I request members to join for this program. And we have a one-day seminar on 26th November, search seizure on GST, income tax and companies law. In December 2nd and 3rd, we are having a real estate and RERA program, 2 days conference. With this once again, thank you all. Thank you, Sanjay sir. Thank you. Thank you, sir. Thank you.